Hello everyone, welcome to Court with Krissy. Time for an update. Last time I gave this guy the benefit of the doubt, because technically there was a jurisdiction issue. But now that he's found his way to the right courtroom and there's still a jurisdiction issue, yeah, I'm going to say this is legit and he's trying to SovCit. See how it goes. I hope you like it. Court with Krissy is now in session.
All right, Mr. Soloway, if you can unmute, please. Thank you. Okay, we're on the record now in Bank of America versus Soloway, file number 2514734. Mr. Zarhan, you're appearing on behalf of plaintiff, is that correct?
Yes, Your Honor.
Okay, and Mr. Soloway, you're appearing on your own behalf, is that correct?
I am.
Okay, so this is set for hearing today on plaintiff's motion for summary disposition. I think we do have a threshold issue, though. I want to hear from both sides on this. I reviewed the file prior to the hearing today, and it appears that this is a file that was transferred by order of Judge Elsenheimer in the 13th Circuit, transferred jurisdiction to this case. But in reviewing the file, it's my understanding, Mr. Soloway, that you're challenging personal jurisdiction, or you did, of the 13th Circuit Court, and that are you challenging the jurisdiction of this court as well, even though the file's been transferred here?
Absolutely. The 13th did not have jurisdiction. Just because they referred a case over doesn't mean that they gave it jurisdiction or that they had jurisdiction. Doesn't mean that at all.
I understand. I'm just trying to understand and get clear for the record what your position is. So you argued that in the 13th Circuit, but that continues to be your position even here in the 46th Circuit. Is that correct?
That's correct.
Okay, so Mr. Zarhan, in my view, that's a threshold issue that the court would have to determine before passing on your motion for summary disposition. But what's your view on that?
Well, yes, Your Honor, and the defendant was personally served address in Fife Lake by personal service, which was determined to be, I believe, in the 46th Circuit Court. So we then, after determining that, the venue was transferred and the defendant was personally served in October of last year at that Fife Lake address, and the jurisdiction was then transferred over to the proper venue. So personal service was effectuated and transferred over to the proper court, which we learned was the 46th Circuit. Personal service remains intact.
Okay, so Mr. Holloway, what's your response to that argument?
Just because I happen to be somewhere doesn't make me a resident. It doesn't give Calcasieu County any jurisdiction. He hasn't shown anything that says that I am a resident of Calcasieu County. In fact, I have a Mississippi driver's license and I vote in Mississippi.
Okay, do you dispute that you were served with the summons and complaint on July 7th, 2024 at 2:59 p.m.?
No, I don't.
Okay. All right, Mr. Zarhan, what's your response to Mr. Soloway's argument?
Well, and Your Honor, by Mr. Soloway not, or I should say by acknowledging the fact that he was personally served at that time, that delivering a summons and complaint to the defendant personally, to mean that personal service is effectuated when the defendant is left with documents in their physical control after being offered and then being informed about their contents. That's Barclay versus Crown Building and Dev 241 Mich. App 639. The defendant was served. That was his residence that we had. The documents were given to him at the time. It was in the 13th Circuit Court. The defendant's argument was it is not the 13th Circuit Court because this is where I was personally served with these documents, at that last, there was no change of address nor any other address or domicile given after that address. So with that being the last address that was on record, the last confirmed address where the defendant lived, the last confirmed address that the defendant was where he was given possession, physical possession of those documents, which he signed for, that is the jurisdiction, that is the proper jurisdiction until as of now, as of then and as of now. And Mr. Soloway has confirmed as such that he, in fact, was served with those documents.
Okay. All right. I'm going to take a short break. I need to look at some case law. I'm going to ask both of you to just remain on the line for just a couple minutes, and I'll be right back. Okay?
Well, he's making an assumption, and the 13th district made an assumption that it was all about the 13th district. It never was about the 13th district. It was all about me being someone from Mississippi and not from Grand Traverse County, and them being a mix-up regarding what county was being, served and all that crap. So it was never about that, and they never clarified that, and it wasn't my job to clarify that. We are clarifying it today.
Okay. All right. Thank you. I'll be right back on the record in just a couple minutes. I'm going to ask both of you to remain on the line, and I'm just going to put you both in the waiting room, and I'll bring you right back in 5 to 10 minutes. Okay?
Your Honor, just to confirm, did you receive the response to defendant's motion to dismiss?
No. All I got was your motion for summary, so no.
Oh, you don't. Okay, you don't have the motion or the response.
I have Mr. Soloway's motion to dismiss. I have your motion for summary disposition, but I don't have any other filings from either side.
Okay, thank you.
All right. I'll be back on the record in 5 to 10 minutes, as I indicated. Okay, we're back on the record. So as to the question of whether or not this court has jurisdiction over Mr. Soloway, the court points to MCL 600.701, which provides that the existence of any of the following relationships between an individual and the state shall constitute a sufficient basis of jurisdiction to enable the courts of record of this state to exercise personal jurisdiction over the individual, and to enable such courts to render personal judgments against that individual. Subsection 1, presence in the state at the time when process is served. So as the file indicates, Mr. Soloway was served with process personally in Fife Lake, Michigan, within Kalkaska County on July 7th of 2024 at 2:59 p.m. So therefore, jurisdiction under 600.701 is satisfied as he was present in the state when he was served with process in this case. So the court denies Mr. Soloway's motion to dismiss for lack of jurisdiction and finds that it does have personal jurisdiction over Mr. Soloway. So with that being determined, Mr. Sarhan, we can proceed with your motion for some disposition. I did have a chance to review your motion and the brief. Is there anything that you wanted to state in support of that?
No, Your Honor. I apologize to the court. I was operating under the presumption that a response was received, so forgive me for that. Regarding our motion for summary disposition, Your Honor, we'll just rely upon our pleadings as you had a chance to review them, and we'll gladly answer any questions the court may still have. Thank you.
All right, Mr. Soloway, do you have any argument regarding Mr. Sarhan's motion for summary disposition?
Well, Your Honor, I would like to adjourn this and take the time to answer his motion for summary disposition, because today I was prepared to deal with jurisdiction, so I did not take the time to deal with all of the other issues that came up, because just jurisdiction is the first item that we had to get through.
All right, Mr. Soloway, I'm not going to grant you any kind of extension. The motion for summary disposition was filed in a timely manner. You were provided notice with the hearing of today. Today's the date for the hearing on that. So if you have any arguments to make, now is the time to make them.
I'm not prepared to make any arguments at this time.
Okay, all right, then the court finds that with any lack of argument to the contrary, and the court having reviewed the motion for summary disposition, it's pretty clear to me based on the documents submitted in support of that motion that there was a valid contract that was entered into between Mr. Soloway and the Bank of America, that he did fail to make payments as required under that contract. And that he failed to do so. And so the court finds Bank of America is entitled to judgment against Mr. Soloway for the outstanding amounts, and the court will grant the motion for summary disposition. Mr. Sarhan, I would just ask that you submit an order reflecting the ruling of the court today and submit that under the 7-day rule.
Yes, Your Honor, we will submit the proposed order and proposed judgment, yes.
All right, that's all I have for today, and both sides are free to disconnect at this time.
Thank you, Judge.